Okay, let's dive right into this explainer. Today, we are exploring a truly fascinating tension between a worker's right to a fair hearing and the complex, sometimes messy realities of the judicial system. Welcome, everyone. We're looking at a massive landmark legal showdown from the Constitutional Court of South Africa. The case is Sakawu, that's the South African Commercial Catering and Allied Workers Union, versus the Seafood Division of Irvin and Johnson. Now, at its core, this isn't just about a labor dispute at a fish processing plant. It's actually a profound exploration of human psychology, the very nature of judgment, and what it really means to get a fair trial. Think about it. If judges have previously used incredibly strong words to condemn a union's actions, can those exact same judges be trusted to impartially hear a new case involving the exact same union members? That is the explosive question we are answering today. We've got a super clear roadmap for today's analysis. First, we'll unpack the concept of bias. Second, the events of two strikes, one union. Third, the legal test for a recusal. Fourth, the majority's verdict. And finally, number 5, the dissenting view. All right, let's lay down the foundation with Section 1, the concept of bias.
So I want you to ask yourself a question. Is it actually possible for a human being in a black robe to be completely 100% neutral? It's super tempting to say yes, right? I mean, we all want our justice system to act like this perfectly balanced, emotionless scale, but the law, incredibly enough, recognizes that this is a total fantasy. Judges have lived full lives. They have experiences, they have baggage, and they have perspectives that just inherently shape how they view the world.
And this brings us to a really vital legal distinction. The Constitutional Court actually established that absolute neutrality is what they call an impossible chimera. Basically, it's a myth, because judges are ultimately human beings. But impartiality, now that's different. Impartiality is defined as having an open-minded readiness to be persuaded by the evidence. You don't have to be a completely blank slate, you just have to be genuinely willing to change your mind when the facts demand it. And that impartiality is an absolute, non-negotiable requirement for a fair trial. Let's look at how this played out in the real world in Section 2, two strikes, one union. The chain of events here is just a brilliant illustration of how legal crises are born. Back in June 1995, there was a union march at the factory that completely brought production to a standstill. The workers involved in that got final written warnings. But then things escalated. In August 1995, a second round of protests broke out over those very warnings, and that led to a huge wave of dismissals. Fast forward a few years to May 1999, and the Labor Appeal Court issues a judgment. This is known as the Nimoy Appeal, confirming the dismissal of the August protesters. But waiting in the wings was a second, separate appeal for the workers' discipline during the initial June protest. The catch? It was scheduled in front of the exact same panel of judges. To really grasp why the union started to panic, we have to look at what Judge Condrati wrote in that first judgment back in May '99. While evaluating the August protests, he used some incredibly strong language. He wrote that the union was determined to build upon the image of the defiant union it had begun to establish in June of that year. You see what's happening there? The judge is directly linking the behavior in August all the way back to the events of June. And he totally didn't stop there. He went on to describe the workers' behavior during their disciplinary hearings as manifesting an attitude of a confrontational sullenness. Wow. You can completely see how this forceful, highly evaluative wording would absolutely terrify the group of June protesters whose appeal was up next. They're sitting there reading this judgment and thinking, well, these judges have already decided we're defiant and sullen. But here is the absolute smoking gun quote. When confirming the dismissals of workers who participated in the August strike, Judge Condrati noted that those who already had warnings from the June unrest doubly deserved to be dismissed. Seriously, put yourself in their shoes for a second. If you were a factory worker reading this exact quote about your own June protest, wouldn't you think the judges had already totally made up their minds? The union definitely thought so, and that is exactly why they filed a formal application for the judges to recuse themselves, which basically means asking them to step down from the case. This brings us to Section 3, the test for recusal. So how do you actually prove a judge shouldn't hear your case? It's really tough. Overcoming the built-in presumption that judges are impartial requires crossing a massively high threshold. In South African law, this is known as the SAFU test. It has 4 key pillars. First, courts always presume judges are impartial right out of the gate. Second, the burden of proof is entirely on the person asking for the recusal. Third and fourth, the apprehension of bias has to be held by a reasonable person, and it must be based on reasonable grounds. So it's this double requirement of reasonableness. Basically, it's not enough to just be honestly anxious or a bit paranoid. Your fear must be objectively justified by cogent, convincing evidence. Let's see how the court applied that test in Section 4. the majority's verdict. Justice Cameron, writing for the majority, anchored his argument in the actual nature of an appellate court. He argued that appellate judges are fundamentally different from trial judges. Think about it. In a trial, a judge is actively shaping the case, listening to live, breathing testimony, and making on-the-fly credibility assessments. But in an appeal, judges are evaluating a crystallized, cold written record. They also operate collegially, meaning they sit in panels with other judges, which naturally dilutes the personal quirks or dispositions of any single judge. Because of this institutional design, the majority argued that the presumption of impartiality is actually much stronger at the appellate level.
Furthermore, the majority drew a really sharp line between the two cases. In the first appeal, the Nemoya matter, the court was laser-focused on the August protests. The events of the June march, those were just uncontroverted background information. In fact, the union hadn't even disputed the employer's version of the June facts during that specific trial. So Justice Cameron concluded the threshold for bias simply wasn't met. The judges were literally just commenting on uncontested background facts. This meant the workers in the new appeal still had an untrammeled, completely open opportunity to explain their actual conduct and argue about the fairness of their specific sanctions. To the majority, the legal issues were totally separate and distinct.
But as is often the case in constitutional law, there was another side.
Section 5, the dissenting view.
Justices Magoro and Sachs offered a deeply empathetic, human-centric counterargument. The dissent forcefully argues that we actually need to assess this situation from the perspective of a reasonable layperson, a factory worker on the ground. A factory worker shouldn't be expected to understand the highly technical legal nuances of overlapping appellate issues or the difference between uncontroverted background facts and live issues, right? All the worker sees is that the exact same judges who are about to decide their fate have already published a legal document labeling their union as defiant, their attitude as a confrontational sullenness, and their actions as doubly deserving of dismissal. To the dissent, it is entirely reasonable for that layperson to fear they won't get a fair shake. What this really highlights is how constitutional law is so often about competing, yet equally valid philosophies regarding what constitutes true fairness. On one side, you have the majority relying on institutional logic, the technical separation of legal issues, and the strict necessity of a high burden of proof, mostly to prevent litigants from just judge shopping whenever they get nervous. But on the other side, the dissent champions a human-centric approach. They prioritize the context of the layperson, arguing that when a judge uses incredibly strong evaluative words, it naturally creates a reasonable fear of prejudgment. Both sides desperately want a fair legal system, but they fundamentally disagree on how you actually measure that fairness.
Ultimately, this explainer leaves us pondering the highly subjective nature of justice. The majority ruled against the union, meaning the judges did not have to step down, and the legal system upheld its institutional integrity. But here's the thought I want to leave you with today. Despite a judge's perfect training and despite the technical separation of the cases on paper, does the system actually work if the person standing before the bench reasonably fears the game is rigged against them from the start? It's a profound, challenging question about the appearance of justice versus the mechanics of law, and it's one that will absolutely continue to challenge courts around the world. Thanks so much for joining me on this deep dive into the anatomy of judicial recusal. Catch you next time.